Hello and welcome. My name is Brad Frazer. I'm here with Jonathan Wheatley. We're attorneys at the law firm Hawley Troxell in Boise, Idaho. We're here to do a recorded session of our Idaho Crypto Summit that was presented live first in Boise, Idaho on May 24th. We wanted to create a recorded version of it and make it available to people who couldn't attend and for others who had expressed an interest in these topics but weren't able to participate in that live session. We'll begin today with Jonathan Wheatley. Jonathan's going to talk about the current regulatory environment for crypto, all things crypto. And then he'll turn it back over to me and I'll talk about the intersection of NFTs and copyright law. I'm principally an intellectual property attorney, as is Jonathan. So we have an intellectual property perspective on cryptocurrencies and all things crypto. So we hope you enjoy our presentation today. Jonathan and I will have contact information presented at the end of the slide deck. We would invite you to note that information and follow up with us directly via email or phone if you have any questions. So with that, I'll turn it over to colleague Jonathan Wheatley to talk about the current regulatory environment of crypto. Jonathan.
Thank you, Brad. Making sure my screen is up. It looks like I'm sharing, so we are good there. As Brad mentioned, I'm going to be discussing the crypto regulatory environment. I'm going to be focusing on the environment beyond Idaho, but I will kind of bring in a little bit of the current regulatory occurrences that just happened and legal occurrences at a statutory level that just happened here in Idaho. But my primary focus with my portion of the presentation is going to be on the federal regulatory approach to cryptocurrency. Now, I think before you start a presentation, it's always kind of good to discuss why you're having the talk that you're having. And I think with cryptocurrency, it's very timely for a variety of different reasons. In the last few months, we have seen a huge spike in, well, not just in the last few months, but cryptocurrency as a whole has seen a large number of instances of theft, of rug pulls, of all sorts of different issues that are not necessarily unique to cryptocurrency, but that seem to play cryptocurrency more than other investments or assets, however you want to define those. And this is apparent in all of the news cycles. So back on the 24th, when we were first giving this presentation, I went ahead and I pulled a bunch of headlines, and I think that that just sort of shows the timeliness of the topic that we're discussing. And it didn't take me long to find just page after page of, such and such exchange hacked for so many thousands of dollars or millions of dollars. This cryptocurrency or token was target for a rug pull. And these headlines just kept coming. So of course, in response to that, you do see the flip side of the coin, and you also get to see that fortunately, things are being done about this. And you can see here, I was able to find an article about the SEC is going to be adding staff to ramp up its anti-cryptocurrency scam efforts, that they halt crypto-themed investment scam. This is just a common occurrence that we've seen over the last few years and that I expect to continue. Before we get into the bulk of the conversation, I think it's important, though, to discuss what is a cryptocurrency and what are we actually talking about? Are we talking about cryptocurrency versus digital assets, and what's the distinction between the two? The way I like to picture it is sort of a Venn diagram, but in the larger circle that contains everything that's digital assets is a smaller circle that's entirely inside the digital assets bubble. So cryptocurrency is a type of digital assets. All cryptocurrency are digital assets. Not all digital assets are cryptocurrency, though. There are other things that fall outside of that bubble of cryptocurrency, such as things as NFTs, which Brad's going to be discussing a little bit more about. There are some distinctions between tokens and coins. For the purpose of this discussion, though, it's not that important that we get into the nuance of all of those. And just know that in general, we're talking about what most people use commonly as cryptocurrency, which can cover stable coins, it can cover utility tokens, it can cover pretty much anything that you could trade through Coinbase. We're going to just call all of those things cryptocurrency and know that there are technicalities between how certain cryptocurrencies and tokens and stable coins and things of that nature function. But from a regulatory approach, they're all treated as essentially the same. Now, how are these cryptocurrencies and digital assets regulated in the United States? I wouldn't be a lawyer if I didn't give the classic lawyer answer, and that's it depends. Cryptocurrency is essentially subject to just a patchwork of regulation from a variety of different entities and different agencies. You also have state interests, and I'll kind of touch on those briefly. As I mentioned, my focus is on the federal regulatory environment, but really you've got just a conglomeration of all of these different federal agencies that are working together to kind of bolster up the regulatory environment. How you're going to be regulated depends very widely from person to person. Generally, when we had this conversation back in May, I was able to kind of approach the room and ask, how many of you are looking to be a startup and actually issue coins? How many of you are wanting to broker and actually create a crypto exchange? And almost every single person in the room said at the most, they really only wanted to know what they needed in order to start up a coin. Not many people. There was one person in the entire room that said maybe they'd be interested in starting up an exchange. Because that was generally the polling data that we got from the first time that we gave it, my focus in this rehashed presentation is going to be primarily on those that just want to start up and create a token and issue it to the public. So, as I mentioned, depending on what you're doing, you're going to be subject to different types of regulations. And you've got all of these different parties that are going to be regulating you in different ways. The SEC is going to be the largest one, and we're going to get into them more in depth than any of the others. And then we've got the Commodity Futures Trading Commission, the Financial Crimes Enforcement Network. I don't know why my presentation is moving around like that. We also have the Office of Foreign Asset Control, the U.S. Prudential Bank Regulators, which OCC, FDIC, all of the names that you typically associate with having your bank insured, your deposits at a bank insured. Of course, you've got the IRS because they want their piece of the pie. And finally, you've got the Department of Justice for when things go wrong. As I mentioned, there's an overlay onto this federal regulatory environment of state laws that you also have to consider. And this is going to be variable depending upon which state you are in. You'll see that Idaho made the list with the recent state digital asset acts. I'm not going to get into that too heavily, but just know that Idaho essentially through this act, which was not a regulatory act, it was a statutory act that went through, our legislature, was signed by the governor. So it is a statutory law in Idaho, but this effectively identified digital assets as personal property. This has some minor implications for how this personal property is treated in various capacities, but not really important from a startup perspective. But that's what that new law did. Before I jump into the next slides, please know that these slides are very, very text heavy. Essentially, what I did was I looked for the primary enforcement actions that all of these different agencies have taken. I'm not going to go through and read all of them. If you are interested in getting the information and can't see it well in this video stream and I'm moving too quickly through the slides, feel free to reach out to either myself or Brad, and we'd be happy to provide this slide deck for you. And you can read the chronological events that have occurred by each one of these agencies and enforcement actions that they've taken. I also, at the beginning of each one of these sections, included just a little blurb about what the regulatory environment looks like. Most of them are not going to be applicable, as I mentioned, to the vast majority of you that are interested in the crypto space, since most of them don't necessarily apply to those that are only looking to mint and distribute a currency of their own. So of course, you've got the FinCEN, and as I said, I'm not going to go through each one of these enforcement actions, but know that there are a good number of them. Then you've got the CFTC, Commodity Future Trading Commission. One of their biggest guidances that they've delivered was the final or the actual delivery guidance. And basically that set up the 28-day rule. And if you're going to be offering a cryptocurrency that's acting as a commodity, which is the vast majority of them, then you need to have them on a CFTC regulated platform, or you need to make sure that the person that's obtaining the cryptocurrency has full control over the cryptocurrency within 20 days of the transaction occurring. Just a minor rule that might affect a few of you out there, but know that it exists and that there's guidance here in this slide that you can go back and refer to and look into in greater detail. Again, more enforcement actions just in a chronological order. I'm not going to get into those heavily. Further continuing those enforcement actions and even further. Then you've got OFAC. This is a lot of the same, just general enforcement actions that you might want to know if you're outside of the typical group of people that we identified earlier in this presentation. Same with the OCC. The FDIC. Now, the DOJ is obviously very interested in this area, and I'm going to spend a little bit of time here because the DOJ is the one that's trying to prevent this crime from occurring in the first place. They have begun, as I mentioned earlier with that presentation, various agencies have been adding extra funding to help prevent this crime from starting and from growing because it is very ripe for abuse. So back on October 6, 2021, the DOJ announced that they're going to be creating a national cryptocurrency enforcement team, and the FBI is forming a virtual asset exploitation unit. We were lucky enough in our initial presentation to have a former FBI agent there who kind of discussed the facts behind the various different teams. And he said that he fully expects to see these teams grow and expand as we progress into the future. And as these types of currencies grow, we also expect to see further scams and the number of those that are negatively impacted by cryptocurrency grow as well. So here are more enforcement matters from the DOJ, and all of these are criminal actions that they've sought. Here's where we're going to be spending the bulk of our time, though. And this is SEC regulation. This is going to be basically the bread and butter for anybody that wants to set up a cryptocurrency. We have to look back to a case that actually occurred in 1946. So we're applying 1946 common law to 2022 cryptocurrency, which is kind of crazy that this is the platform and framework that we have to assess what we're doing with today's digital assets, but it's what we've got, and it's how you determine what is or isn't a security. So this is going to play a huge role in whether or not you are subject to all of the regulations, well, not all, but a good number of the regulations that the SEC has. If what you're offering is considered a security, then you have to go through a huge number of steps with the SEC to make sure that what you're offering meets certain regulatory guidelines as defined by the SEC. And how they determine whether or not what you're offering is security is done through this 1946 test. And the test is known as the Hawley test, from the case that basically founded this test. And they look to see whether or not there's an investment of money. This one's almost always going to be met because somebody's giving money to somebody else in return for something, for some digital asset. They're going to look to see if it's a common enterprise. Basically, is that person giving you money to go and start on some sort of business venture together? Are you in a common enterprise working towards a same goal? is there an expectation of profits that you're expecting to get from purchasing this digital asset? And this expectation of profit is most likely to be what trips most people up. They are going to look to see how you're marketing your digital asset. Are you telling people you're going to get a 10% return on everything that you give me for the next 20 years? And at that point, things start looking a little bit suspicious once you get into those higher expectations. And it doesn't even have to be a higher expectation, but if you're marketing and saying, this is going to go up 5% a year, then you're starting to market your digital asset with some expectation of profit. And as soon as you do that, then you're gonna check that box, and that's gonna look really, really bad. And if all of this is done based on the efforts of others, so if by me giving you money, I walk away and you're just giving me back 10% profits every single year, and I don't have to put in any effort, then you most likely just passed or failed, depending on how you want to frame it, all of these factors in the Howey test. And if you hit all of these, then you're going to be subject to the Howey test and you're going to be considered a security. And because of that, you're going to have a huge cascade of effects. So what you're going to want to do if you are looking to offer a coin is to basically look at this Howey test in reverse. You're going to want to, and some of these you're just not going to be able to get away from. The easiest one that's going to be most within your control is the reasonable expectation of profits. If you're just saying, hey, buy my digital artwork, it's really cool, it's artwork, you're not going to necessarily get in trouble for that. But if you say, buy my digital artwork, it's going to go up 100% in the next year. Look at this graph of how much NFT profits have grown over the last few years. This could be you with my NFT that I just minted on the Ethereum blockchain. Once you start setting up those expectations, you are looking to fail that test. So market yourself knowing these 4 factors and purposefully avoiding giving anybody reasonable expectation of profits. That's going to be by far the easiest way to avoid getting in trouble with the SEC and to get away from passing or failing the Howey test, depending on how you want to look at it. Knowing all of that, here are people that the SEC has gone after, and you can see the list is ever growing. There's quite a good number of them. Oh, I'm going to go back to this slide quickly. So they have proposed a safe harbor, which would give you time to sort of develop and decentralize your platform. Right now, there are certain rules that are potentially going to be in play for decentralized currencies. If it's decentralized, then what it does in the market doesn't really fall back onto one particular group. Bitcoin, there isn't a Bitcoin headquarter that you can go and sue because it is more or less decentralized. You could argue that it is because, or isn't because, the vast majority of Bitcoins held in a very small percentage of the wallets, but for purposes of how the currency was dispersed and being under common control of one party, it doesn't meet that. So the SEC has tried to dabble with the idea of creating some sort of safe harbor provision that would give companies time to get their currency up and running and allow it to become more decentralized. But that's in the works and nothing has officially passed yet. More enforcement actions. It looks like I am coming up on time, but we're going to skip forward a little bit to President Biden's executive order on digital assets. And back on March 9th, Biden issued an executive order basically asking every single large regulatory agency that we just looked at in that big full list and that we kind of glossed through to identify issues that might fall under the purview of that particular agency as it relates to cryptocurrency, and to come up with potential solutions that might help all of the scams and all of the issues that are happening in the crypto environment. Now, this executive order had a timeline on it. So it was 180 days for various agencies and then 210 days for certain others to provide feedback to the president on what they found. being that March 9th was the day that the issue was ordered. We're looking at early September for the 180-day deadline and early October for the 210-day deadline. With these updates, I really expect to see a good number of future proposals for the future of cryptocurrency. And I think that that will actually be a good thing. We heard multiple times in our presentation when it was live that a lot of these businesses are actually kind of sitting on the sidelines waiting for just better guidance on what they can and can't do. Right now, because there is no guidance, it's too much of a risk for a lot of the big players to really get involved. And they would feel a lot more comfortable if there were some sort of a framework that was more clearly spelled out that could actually give these companies, the green light to jump in and to know that everything that they just put in, the tens to hundreds of millions of dollars aren't just going to be washed away because of some regulatory change. Once we see that, I expect to see crypto begin to take off a little bit more, and then I expect to see a coalition of power. I don't think that we're going to have, all of these different, toilet paper coin and Dogecoin and Dogecoin too. I mean, I don't expect to see all of these continue to exist in perpetuity. I mean, they might exist, they might be out there just in the ether, in the internet domains, but I expect to see power coalesce around a few good utility tokens. And I think that we'll see that occur much more rapidly after those agencies provide their feedback to President Biden. So with that, I will pass things over to Brad, who's going to talk to you all about what you really get when you buy an NFT. And I just butchered that title and did not read it verbatim, but I'll pass it over to you now.
Thanks, Jonathan. Very well. Well, thank you, Jonathan, for dealing with a very dense and difficult topic, the regulatory environment of crypto. So I hope if any of you who are watching this have questions, please reach out directly to Jonathan, because that landscape changes almost daily in terms of current regulation. And so the question we always get is, well, can I do this? Can I do this Web3 thing? Can I do this crypto thing? Can I do this coin, this token? And the answer is sure you can. And the reason you can is because at the moment it's not really regulated. It's unlikely you're going to go to jail. It's unlikely you're going to get shut down by the SEC or the DOJ or the Idaho state regulators. Unlikely, not impossible. So we encourage people to proceed with caution because the regulatory environment is so uncertain. But for up-to-the-date information on that topic, please reach out to Jonathan Wheatley. He's a fountain of knowledge on these things. Also, we've been sort of generically using the term crypto, and we've called this the Crypto Summit. But, really, we're talking about all kinds of blockchain implementations, Web3, metaverse, cryptocurrencies, NFTs, smart contracts. Those are all blockchain implementations. And so our topic's really much broader than just crypto. And in fact, one of my clients said that the word crypto is now somewhat pejorative. And so when he has a Web3 business, a metaverse business, and he doesn't want to have it referred to as a crypto thing for that reason. So when we say crypto, we really mean all blockchain implementations. And of course, talking about blockchain and cryptography is beyond the scope of this session. But if anybody wants to have a more in-depth discussion about those topics, please let us know. We'd love to get on a call, a free initial consultation with you and talk about it. Okay, so with that, let's move into my session, which is, what do you really get when you buy an NFT? And I think I just did the same thing Jonathan did. What do you get when you buy an NFT? Really? Question mark. Okay. A lot of interesting discussion about NFTs and what they are and what they do. And they're very popular. And Mark Cuban is into NFTs and athletes are into NFTs. And there's a website called OpenSea.io. Its whole purpose is to talk about NFTs. So let's talk about it together. So to best understand what an NFT is, we have to begin by talking about what is a copyright. A copyright is an intellectual property right that springs into existence when a sufficiently creative idea is reduced into or onto a tangible medium. So a lot of words there, but the key is that it is something creative and tangible. When you take a creative idea, whatever it is, and reduce it to a tangible medium, such as taking a photograph or writing something on paper or sculpting clay, you've created a copyright as a noun. And so, for example, if you were to take your phone out and take a photograph right now of your computer screen or the landscape out your window, you would literally be creating a copyright. A famous example of that is found in this selfie that was taken at the Oscars a few years ago. And there was discussion on social media about who owns the copyright of this photograph. We have Jennifer Lawrence, we have Ellen DeGeneres, Bradley Cooper, we have Brad Pitt, looks like a couple of other famous celebrities in that photograph. I think that might be, I can't tell who some of those, oh, there's Kevin Spacey back there. So a question arose on social media after this photograph was taken as to who owns the copyright. And the answer is actually whoever clicked the button on the phone to create that selfie. It's probably, I think, Bradley Cooper is what we all agreed at the end of the day, because it looks like he's holding up the phone, doesn't it? So interesting that all those celebrities are in that picture, and yet Bradley Cooper probably owns the copyright because he's the one who composed it and took the photograph. And so all those other people might say, well, we're in it, we own a copyright too. And that may or may not be true based on a lot of different legal theories. But this is, I think, a good example of the doctrine of it's creative, it's tangible, and Bradley Cooper owns the copyright because he's the author. So copyright's a noun. It is a creative expression of an idea that's reduced into or onto a tangible medium. As a general rule, the owner of the copyright is the author, the person who reduced it to a tangible medium. Now, I've used the phrase sufficiently creative, and this always creates a lot of questions with clients. What does sufficiently creative mean? And this slide hopefully will demonstrate that concept. Remember, a copyright is a noun. It's a property right that springs into existence when a sufficiently creative idea is reduced into or onto a tangible medium. So what is sufficiently creative? Well, on the left on this slide, you can see that that is sufficiently creative. That is a beautiful landscape. I can't tell if that's a photograph or an oil painting or an acrylic, but that's sufficiently creative. It shows a lot of artistic merit, the composition, the craft. It's got a lot of content. So that is sufficiently creative. Even if it's a photograph, you might say, well, yeah, the person who took the photograph didn't literally create those mountains and those trees. No, but they composed the photograph, and that's creative, sufficiently creative. So that is copyrightable subject matter. Contrast that with the logo on the right. Let's assume that that is your new logo for your company, and you want to protect it using not only trademark law, which is a different topic, but you want to protect it using copyright law. Copyright law would not allow you to protect the logo on the right. Trademark law would, perhaps, but not copyright. That's insufficiently creative. So somewhere between those two extremes lies sufficiently creative, and it's a continuum, and we know it when we see it. So if you have a question about whether something is copyrightable and you don't know if it's sufficiently creative, look back at the slide and ask yourself, where on this continuum does my particular work exist? Is it insufficiently creative, a triangle with a couple of lines and a circle in it, or is it a complex work of art like the thing on the left? The seminal case for this, if you want to look it up, where you're a lawyer or you are a lawyer and you want to look it up, is Feist Publications, and there's a citation at the bottom. And that tells us that in order for something to be copyrightable subject matter, it has to pass what is called, it transcends what used to be called the sweat of the brow doctrine. It now has to comport some kind of sufficient minimal level of creativity. It's a low threshold, but you still have to be sufficiently creative to have copyright protection. So I thought this would be a good time for me to offer a shameless plug for my book. So hold up your phone, open your camera app, and point it at that QR code, and that will take you out to my publisher's page for my book. And the reason I stuck that in there, not only is the same shameless plug to try to sell some books, quite frankly, but because it's a demonstration of the fact that I own a copyright in that book. It's sufficiently creative. It's reduced to a tangible medium. I wrote it. I didn't copy it from any other source. So I own a copyright in that book, and I've registered the copyright. And so you might want to, if you're looking for a good beach book or a weekend read, you might hold your phone up to the QR code and get a copy of the QR, example of a copyrightable subject matter. Okay. A few more notes on what is a copyright. We talk about the phrase automatic upon fixation. What that really means is that the copyright springs into existence as a noun when it's fixed in a tangible medium. People often get confused about that, and they think that they have to put a circle C on it, or that there's something that they have to do to have a copyright. No, All they have to do is have a sufficiently creative work that's produced into or onto a tangible medium. Fixation is the act of placing it into the tangible medium. And when you've done that, copyright is automatic as a noun. You own a copyright. But remember that there are different concepts here. There's creation of a copyright, automatic upon fixation. There's ownership of a copyright, generally speaking, owned by the author, the one who does the fixing into the tangible medium, generally. And then there's a related doctrine or concept called registration. So creation, ownership, and registration, all important, all different. So to review, we've talked about creation of a copyright as a noun, automatic upon fixation, sufficiently creative, tangible. Ownership, general rule, many nuances to this. If you want to talk about it, call me or email me. General concept is that the owner of a copyright is the author who reduces it to a tangible medium. Now, it's interesting that in the United States, the moment you create a copyright as the author and you have fixed a creative idea into a tangible medium, automatically and without more, you have these exclusive rights. Under this law, 17 U.S.C. section 106 that's cited there, you're the only one who may lawfully do those things. So if you take a photograph with your phone, it's sufficiently creative, you've reduced it to a tangible medium, you're the author, you own the copyright as a noun, great. Without more, without anything else, without Circle C or government filing or anything, you're the only one who may lawfully do these things, the only one who may lawfully make copies of the work, distribute the work, make derivative works, publicly perform and publicly display the work. So think this through. If someone were to get onto your Facebook feed and copy a photograph that you posted there that you took, and they do something else with it, they make a copy of it, they print it out on their printer and hang it on their wall, they put it on a t-shirt, that's copyright infringement without more. It's automatic. It's an automatic right granted to the owner of a copyright under 17 U.S.C. section 106. That's important to remember because you own a lot of copyrights and you have a lot of exclusive rights to those works. But there's one additional step. Remember, we talked about authorship, ownership, and lastly, registration. So even though they're called the section 106 rights on that prior slide, even though they are automatic, the moment you have created a copyright and you get those exclusive rights automatically under the law, to enforce those rights in court, now under this case, Fourth Estate, you have to have a registered copyright. Not hard, not expensive. They do it fairly quickly. So if you are a content creator and you create works of art that you think are sufficiently creative, whether they're text or photographs, whatever they may be, if they're sufficiently creative and they're tangible, you own a copyright. You have those rights under section 106, and you should go out and register those copyrights under the Fourth Estate case. Again, not hard, not expensive, and you should do it quickly. You should register those copyrights as soon as you can after the work is created in what's called the best edition, meaning as soon as it exists in final form, your book, your photograph, your clay sculpture, your software, your computer code, your source code, whatever it is, when it's done and you have a best edition, register the copyright. Okay, so we've talked about copyright as a noun, talked about creation, ownership, authorship, registration. Okay, now let's switch gears and talk about NFTs. Most of you know, because you're watching this session and you have some interest in this topic of blockchain implementation, that an NFT is an acronym for what's called a non-fungible token. As you know, most blockchain implementations are fungible. They're identical from one to the next. One Bitcoin is fungible relative to the preceding Bitcoin. One token minted in the Ethereum blockchain is identical to other tokens and coins minted in that blockchain. They are fungible, meaning they're the same. Non-fungible means different. Non-fungible tokens are to create differentiation from a different blockchain instrumentality like Bitcoin, which is fungible from coin to coin or token to token. These are non-fungible, they're different. And the reason that's important is because people who trade and market and sell and work in the NFT space want consumers to believe that they are all different, one from another, and thus they are identifiable, which is true. I mean, if they're non-fungible, they're able to be identified. You can't tell one Bitcoin from another without significant, work in the blockchain. As a general rule, though, each NFT has its own unique identifier. They're all different. Okay. So the term describes the item resulting when typically a digital representation of a creative work is minted into the blockchain, typically the Ethereum blockchain. Let's look at that second bullet point together and read it together slowly. It's the item resulting when typically a digital representation, like a URL or a URI or a snippet of code of a creative work, some kind like a picture, is minted into the blockchain. They're non-fungible and they're typically minted into the Ethereum blockchain. That NFT is an excellent way to establish what's called provenance. That means authorship. That means who originally authored it and who's owned it in the interim. An NFT is an excellent way to establish provenance of the underlying work of art. Okay, so let's look again at that second bullet point. It's a digital representation of a creative work. That's really important, as we'll see here in a moment, okay? So think about that. This slide is just for the nerds who want to see the difference between a URI, a URL, and a URN. The URI is an identifier and a URL is a locator, and you can see that a URL is a subset of a URI, but they both basically do the same thing. A URI will point you to someplace on the internet. It will identify a place, and in fact, I've read that it may not even be limited to the internet. I mean, you sitting in a chair at home probably right now have a URI, Uniform Resource Identifier. Having said that, however, this is just an indication of what a URI is. It's intended to indicate a location in physical or virtual space. Okay, so now let's go into our NFT case study. On your screen, you will see a work of art called Every Days, the First 5,000 Days. Now, when we presented this live, I asked the audience, what is this? And many people said it's an NFT. And that is the best example I can give you of the misconception people have about what an NFT is. If you go to OpenSea.io, or if you look at the popular press or Mark Cuban, or you watch Shark Tank, or you look at, if you Google NFT, invariably you will see them thinking of it as a work of art like this, like a picture, a digital picture, a picture created with software. And that is, of course, wrong. And this is what we hope to dispel in our session together today. An NFT is not this work of art. They are different, which we'll discuss here in a moment. So this is an underlying work of art. It's a photo collage created by an artist named Beeple. He took each of these 5,000 photographs and he put it into a photo collage. It exists as a JPEG on Beeple's computer or on a server in the cloud. It's just a JPEG digital image that he created. That's what it is. And it's called Every Day is the First 5,000 Days. No different than if you took a picture of your dog as a JPEG and put it on your computer. Same thing, except Beeple made a photo collage. That's all it is. Okay. However, Beeple minted into the Ethereum blockchain an NFT in connection with that picture. So Beeple is presumably the artist of the underlying work, and he is the owner, the author of that underlying digital work we saw on the preceding slide. Now, without more, Beeple possesses all the exclusive rights in that underlying digital work in 17 U.S.C. Section 106. So we have the NFT, we have the underlying digital work, we have Beeple as the author, and we have Beeple owning the copyright in the underlying digital image, and him owning the exclusive rights under 17 U.S.C. Section 106. Note this first bullet point. The NFT that was minted sold for $69 million. Okay, so we have the digital work of art, we have Beeple, we have the NFT, we have somebody paid $69 million for the NFT. All right, now here's our case study. So let's pretend that I go out and print Beeple's image on t-shirts. So there's imagine that I've done that and I can be selling those on Etsy. Okay, so there you go. I printed that digital image. Every day is the first 5,000 days. Beeple created that image, a photo collage. I put that on t-shirts. Okay, question. Does the owner of the NFT also own the copyright? Does the owner of the NFT have the ability to stop me from selling the image on t-shirts? Now, if Beeple, the owner of the underlying copyright in the image, has registered as copyright, he can sue me. That's clear. Beeple owns the copyright in the underlying image. If Beeple is registered as copyright, second bullet point, he can sue me for copyright infringement. That has nothing to do with the NFT. If he'd never minted an NFT, that would still be a true statement. He owns the copyright in the underlying image. it's registered, he can sue me in federal court for copyright infringement, and I have to stop selling those t-shirts. But does the owner of that NFT, $69 million NFT, do they also own the copyright? And by extension, can they stop me from selling those t-shirts? Well, no. Minting and selling an NFT is not an assignment of a copyright. And the reason is because of a little known and a little understood statute called 17 U.S.C. section 204A, which says that the transfer of a copyright is not valid unless there's a signed writing. There's the statute right there. So when Beeple minted that NFT, he did not, as far as I know, in fact, I think Beeple said in the press publicly, he's not assigned the copyright. He did not sign a piece of paper or sign some kind of conveyance transferring ownership of the copyright in the underlying work of art. So minting and selling an NFT does not act as an assignment of the copyright. It just doesn't because of section 204A. So no, the owner of the NFT does not own the copyright. Beeple owns it. Beeple didn't assign the copyright. He owns the copyright in the underlying work of art. The person who paid $69 million owns an NFT, but not the copyright in the underlying digital work of art. So you can see why that's so frustrating for me when people refer to the underlying work of art as the NFT. It's not. It's a work of art, the copyright to which is owned by the original author. So the NFT and the work of art are different. And when you buy an NFT, you do not get the copyright unless there's a separate signed conveyance from the author as part of the deal giving you the copyright when you also acquire the NFT. Note, if you go to the OpenSea.io terms of service, note that they understand this concept. Quoting from the OpenSea terms of service, we do not have custody or control over the NFTs or blockchains you are interacting with, and we do not execute or effectuate purchases, transfers, or sales of NFTs. They're just a broker. So see how they're alluding to the fact that they really aren't transferring any title to anything. They're just a broker. And by extrapolation, this is true. NFTs don't really convey title to anything, and they don't really convey title to the underlying work of art because it's not an assignment of copyright. Okay, so minting and selling an NFT is not an assignment of a copyright. It might be something called an implied copyright license, maybe, to do certain things with the work of art, but even that's not clear just by buying the NFT. So some of you will now be asking, well, yeah, what about smart contracts? Don't smart contracts work to convey the copyright as an assignment under 204? Good question, good question. And the answer is maybe. Smart contracts, and here's a definition of a smart contract I just picked up from the internet. It's a computer program that's in the blockchain. It's an autonomous AI, an autonomous script that runs according to pre-established automated commands. Note that it only affects, though, the NFT, not the underlying work of art. The smart contract only affects, look right there, that's why I bolded it. It gives automated commands to store the NFT, enable the purchase of the NFT, enable the NFT to link to the wallet of the purchaser, and make connections for the underlying NFT transaction. You see how there's no reference to the underlying work of art? Smart contract does not work an assignment of the underlying work of art. That's reason number one. They only affect the NFT, and the NFT is not the work of art. But moreover, and this is perhaps most important, section 202, 17 U.S.C. section 202 makes it clear that the ownership of a copyright is distinct from ownership of the underlying work. Here it is. The ownership of a copyright or of any exclusive rights under a copyright is distinct from ownership of the tangible medium. So not only do we have section 204A that says a copyright must be assigned in writing, section 202 says that a copyright is distinct from the tangible work. So Beeple owns the physical file, but he also owns the copyright. Unless he's assigned it away in assigned writing, he still owns the copyright. Getting a copy of the NFT does not assign the copyright, and the copyright is distinct from the tangible underlying work. The smart contract controls the NFT, not the copyright in the underlying work of art, and the copyright is distinct from the work of art. So here, this is probably the most important slide in the whole deck. This will summarize everything we've been talking about. So there's the underlying work that Beeple created. Digital file, JPEG or PNG on his computer on the left. There's Beeple, the author, a human being, my stick figure representation of the human being author. Then under section 202, we have the incorporeal ghost-like copyright, which is separate from the work. And then we have the NFT. That is the actual non-fungible token. That's the line of code, the URI that was minted into the Ethereum blockchain that someone paid $69 million for. So they didn't get the tangible work of art because it's still sitting on people's computer. They didn't get the copyright because it wasn't assigned in assigned writing. The copyright is distinct from the work. People didn't give it away. And so literally, truly, that person, whoever bought it, paid $69 million for that little line of code there, that URI, that's the thing that was mentioned into the blockchain. It's very expensive and data intensive to mint an entire work of art, a whole JPEG, a whole film, a whole something into the blockchain. And so that's why it's not done, at least not currently, typically. So what you have is that little teeny URI, that literally that thing in the box on the right, that's the NFT. That is what was $69 million was paid for. I don't even know what they bought. I don't know. I mean, what is that? It's not a book. It's not a pair of shoes. It's not a pizza. It's not a car. It's not a tangible thing. It's not a property right. It's not a copyright. It's not a JPEG copy of the work. I don't even know what the law would call that thing, but they paid $69 million for it. And so so absent some additional underlying side contracts with people, I don't really actually even know what they got, except the ability to point to it and say, I own it, and agree that people minted that into the Ethereum blockchain. And so there's provenance going back to the original work. That's it. I don't see that that's worth $69 million, but value is in the eye of the beholder. So summary, by definition, the NFT and the copyright are separate and distinct. I think we get that. Copyright in the work is distinct from the NFT. The NFT is a line of code. That's all it is, minted into the blockchain. So when you buy an NFT, you do not get all the ancillary copyright rights unless you have a side contract with the author. So what, you may say, because the smart contract saves the day, maybe, but that's not necessarily true, because remember, the smart contract only acts to affect the NFT. By definition, it only affects the NFT. The NFT is not the copyright. The NFT is not the work of art. The NFT is only that little URI. And the other death knell here for smart contracts is this case, from a recent case from the Copyright Office. There's a QR code if you want to actually pull up your phone and get a copy of this case, but go right immediately to footnote 8, which says, on current authority, automated systems could not enter contracts because only a person with a mind can be an agent in law. Well, an autonomous script like an AI, like a smart contract, cannot enter into a contract. It has no capacity to contract. So if you're thinking that, the smart contract somehow is legally binding, it's not, because it's not a person. And we now have some authority for that proposition. So you see all the house of cards tumbling down here. NFT is not a copyright. NFT doesn't assign a copyright. The NFT doesn't give you ownership of the underlying work of art. It doesn't give you any of the Section 106 rights. Smart contract, because it's not a person, cannot assign the copyright. It doesn't act that way. And it can't even really grant you a copyright license to work with the underlying work of art. So you can see a lot today under today's scheme, a lot of legal problems with NFTs and believing that they somehow convey ownership or authorship of the underlying work of art, and that somehow the smart contract acts like a contract. It's just simply not a contract. Okay, so here's our pop quiz as we near the end of our session together today. In the upper left-hand corner, right under pop quiz, that's the NFT. That thing is worth $69 million, that little snippet, that URI, that if you backtrack it out, and Jonathan Wheatley helped me do this, if you backtrack that out as a URI using Etherscan, eventually you'll find on your computer monitor a copy of that image, but Beeple still owns the copyright. Okay, so here's a pop quiz. Can the owner of the NFT make copies and otherwise violate Section 106? Answer, no. The owner of the NFT has no rights in the copyright and maybe has an implied copyright license, but technically, the owner of that NFT, if they printed up that t-shirt, that would be copyright infringement, and people could sue them for copyright infringement unless people gave them a copyright license. How about that? What'd you pay $69 million for? Okay, when you buy an NFT, are you getting a digital copy of a work of art? No, you're getting a little teeny line of code that's minted into the Ethereum blockchain, like the one in the upper left-hand corner. So you're not getting a digital copy of a work of art. That's why I get so frustrated when I go to OpenSea.io and it purports to be an NFT marketplace, and you see all these digital works of art. And so you buy one and you think you're getting a copy of the digital work of art, but you're not, unless you strike some kind of a deal with the author, the owner of the copyright. You see the difference?
Okay, upper right-hand corner, who owns the copyright in the underlying image? People, or the author, not the owner of the NFT, completely different. The copyright in the underlying image is owned by the author of the work. Who owns the copyright in the NFT? Well, nobody. Nobody owns the copyright in the NFT because this is why I put that slide up earlier. That little line of code is not sufficiently creative to merit copyright protection. So it's not copyrightable subject matter. Nobody owns the copyright in the NFT, not Beeple, not the guy who paid $69 million. Did Beeple transfer the copyright in the work of art to the buyer of the NFT? My reading is no. He did not assign in a writing, section 204A, the copyright to the buyer of the NFT. So no. And bottom right, can the owner of the NFT sue the t-shirt maker for copyright infringement? Well, they can sue, but that case will be quickly dismissed because the owner of the NFT does not own the copyright in the underlying work of art. I can make and print and sell that t-shirt on your screen all day long with impunity, charge whatever I want, and the guy who owns that $69 million NFT cannot stop me. Cannot stop me. I will win that lawsuit unless Beeple sues me or Beeple gives rights to the owner of the NFT to sue me under what's called an exclusive copyright license, neither of which has occurred as far as I know. Okay. So here are takeaways. Be careful what you represent warrant about title and copyright when you sell an NFT. If you are into the business of minting and selling NFTs, please be careful about what you say. Do not represent a warrant that you're conveying title or copyright, just like OpenSea does in its terms of service. Second, know what you're getting when you buy an NFT. You don't get the copyright unless there's a written assignment of copyright. A smart contract is not a contract. It's not a written assignment of copyright because it's not a person. It can't fulfill section 204A. And moreover, you don't get the section 106 rights because all you're getting is that little snippet of code that's minted into the Ethereum blockchain. If you're selling NFTs, please remember what Jonathan said and do not offer them as securities under the Dapper Labs case, which is a lawsuit in which a company is being sued, Top Shots is being sued for selling NFTs as unregistered securities because they violated the Howey test. They sold an NFT and made an implicit promise of a return on that investment. Well, that's a security. That's illegal. Do you think the owner of the Beeple NFT knows he cannot stop our t-shirt seller? So Beeple, if there's a 1 in a million chance you're watching this, and I'm going to go out and start selling t-shirts with that image on it, Beeple, just so you know, I'm giving you heads up. And you're the only one, and as far as I know, the only one that can stop me from doing that. But do you think the owner of the NFT knows they can't stop me? I don't think so. So, hey, if the owner of that $69 million NFT is watching this, I would invite you to come after me and try to stop me from selling those t-shirts on Etsy that have the Beeple image on it, because you'll lose. I mean, there it is. Okay. So we come full circle. What do you really get when you buy an NFT? I don't know. It's a line of code in the Ethereum blockchain. Is it goods under the UCC? Not really. Do you have a contract, right? Is it a URI? I'm struggling to find out what you really purchased. I guess maybe there's some kind of theory that it's some kind of an asset, an intangible asset of some kind. But again, that's a discussion for another day. Under current US law, you do not get the ability to stop the use or reproduction or public display or performance of the underlying work of art, the thing, when you buy an NFT, because there's no legal mechanism created here. But you do have immutable proof of provenance of the NFT. We know that Beeple minted that into the blockchain. That's what the blockchain does. It's immutable. It's immutable proof that Beeple minted that NFT. You can say, I own an NFT. I own a line of code minted into the Ethereum blockchain by Beeple. You can say that. And if that's worth $69 million to you, then bless your heart. Good for you. All right. So here's our contact information. Jonathan, do you want to come back over and join me here for a second? And we'll just wrap it up. Okay. Well, thank you for listening to our recorded session of our Idaho Crypto Summit, originally presented live on May 24th. Here's our contact information on this slide. Please reach out to me or to Jonathan with questions about our presentation together about crypto, NFTs, or blockchain implementations or regulation. Jonathan, do you have any concluding comments?
I think you've covered it all.
All right. Well, thanks everybody for listening. Hopefully you'll reach out and have some questions for us. Hopefully we'll see more clarity in the blockchain space, both in terms of case law and regulation. But until then, please be careful out there, kids. And if you have any questions, reach out to me or Jonathan. We'd be happy to visit with you about these topics. Thanks for watching today.
Thank you, everyone.